is going to be presented by my colleague, Nayeli Maxine Velazquez, a California attorney who earned her law degree at UC Hastings College of Law with extensive experience in organizational leadership. She served as the executive director and CEO of the Alliance for Community Development of the San Francisco Bay Area and vice chair of the City of Oakland's Ethics Commission. She's also served as regional director for a presidential campaign and has worked for various elected officials at the local, state, and federal levels. So over to you, Nayeli.
Thank you, Mel. All right, so let me get my screen up. Here we go. So we're going to be covering major concepts, and then we'll have a panel discussion. In our major concepts portion, we'll cover theory, municipal laws, enforcement, and global jurisprudence. So those first three parts of our CLE today. Starting with part one, the theory of the rights of nature. So just to summarize what we learned, the Western legal system does not adequately protect the natural environment. A new system based on an indigenous value system is needed in order to protect the natural environment. Western law began exploring the concept of the rights of these types of protections for nature in 1972 with the dissenting opinion in the Supreme Court case, the opinion coming from Justice Douglas. And then we saw limited application in the courts in the United States through standing decisions for animal and plant species. In municipal laws in the United States, we first saw, and in fact this was the world's first rights of nature law, adopted in the Tamaqua Borough of Pennsylvania in 2006. Since then, 36 communities across the United States, including the city of Pittsburgh, have adopted rights of nature laws. The Lake Erie Bill of Rights was adopted by the voters of Toledo, Ohio in 2019, and then the voters of Orange County, Florida adopted a law recognizing the rights of waterways in 2020, overwhelmingly with almost 90% of the vote. In part two, we learned about the structure of the rights of nature municipal laws. Generally, rights of nature municipal laws will contain three primary components: the recognition of rights of nature, ecosystems, or species, recognition of resident standing to enforce those rights in courts, and available remedies, including restoration of the affected ecosystem. We heard about enforcement of U.S. rights of nature laws. So direct enforcement of rights and intervention by the ecosystems themselves. First, the case study in Florida, direct enforcement of rights of wetlands, creeks, and lakes against developer of a large housing project that seeks to fill in wetlands and impact other waters, and that's currently underway. The case study in Pennsylvania, an effort to intervene on behalf of a watershed in an existing case brought by an oil and gas driller against a municipality that had banned wastewater injection wells. And finally, the case study in Ohio with an effort to intervene on behalf of Lake Erie in an existing case brought by an agribusiness interest against the city of Toledo, which sought to overturn the Lake Erie Bill of Rights. And finally, in part three, we looked at the Ecuadorian Constitution's rights of nature provisions that were included within their new constitution in 2008. The first enforced case here was on behalf of the Vilcabamba River against a local government. Many other enforcement cases dealing with mining, shrimp farming, shark fishing. Currently, there are several pending rights of nature cases awaiting rulings in the Ecuadorian Constitutional Court, with decisions expected this year. We heard about other international jurisprudence at Indian state courts recognizing the legal rights of the Ganges and Yamuna rivers. Colombian courts have recognized the rights of the Atrato and Amazon rivers and the Amazon River Basin. along with other waterways and ecosystems. And the Bangladesh Supreme Court has recognized the rights of all rivers in Bangladesh. Okay, so now we're going to turn back to our panelists for a panel discussion. We're going to talk through a number of legal issues, where authority is derived from, government's role. We're going to talk about commonly recognized rights, the judiciary's role, and the attorney's role. All right, so first, Thomas, could you help us talk about what is the legal authority for adoption of rights of nature laws in the U.S. at the municipal level?
Sure. So this is kind of where the rubber meets the road in terms of, rights of nature advocates have been forced in many ways to work at the municipal level because it's difficult at this point to see how this kind of, new emerging concept really finds a home in state legislatures who are generally more about protecting, or elevating certain other rights over the rights of nature, or at the federal government level where it would require a constitutional amendment or some kind of federal statute at least. So we end up at folks end up at the municipal level of law because it's the one closest to them, and is the only place where they can really move these kinds of laws forward. And so from a practitioner standpoint, whether you're representing a community that's come to a decision that they want to pursue something along these lines, or you've been approached as a practitioner on behalf of a community that's already passed them and wants to intervene or enforce them somehow, there's a variety of places where practitioners would become involved in these the advancement of the laws and also the enforcement of the laws. And I think it's also difficult sometimes because as practitioners, we're all in kind of silos. We're either practicing environmental law or we practice municipal law or we practice constitutional law, but this work is really about the intersection of all those different bodies of laws. So suffice it to say, the authority for adoption of rights of nature laws, as practitioners have advanced in the United States over the past 15 years, really comes down to where you are. That municipal powers in the United States differ drastically, whether you're in Mississippi, whether you're in Pennsylvania, not to pick on Mississippi, but if you're in Mississippi or Pennsylvania or Washington or Oregon, the powers that municipalities have differ quite a bit. So it's location, but it's also what kind of municipality you are. So a lot of cities, towns, villages, counties across the United States are what we call statutory municipalities. Their power derives exclusively from the authority that the state legislature and state government deems to give them. And so if you're in a statutory municipality of that kind, your basis for authority generally comes down to the authorizing statute that the state has passed, which gives your municipality certain legislative or lawmaking powers, defines the scope of what the municipality can adopt. And generally in those places, folks have made the argument, advocates have made the argument that the general police power that's given by the state to the municipality to legislate, for the health and safety protection of residents, health, safety, and welfare of residents within the municipality can be read broadly enough to include these heightened environmental protection measures. So if you're in a statutory municipality, that's kind of where you sit, is looking for that specific authority from the state that opens the portal for you to do lawmaking in this particular area, framed mostly as a heightened environmental standard. And you'll find also in some states, they delegate even power of environmental law specifically, or nuisance, that municipalities can adopt laws against nuisances or pass environmental laws at the local level. So if you're in a statutory municipality, that's pretty much where you sit. And then we have these municipalities in the United States called home rule municipalities, which are cities, towns, villages, and counties that under state law operate with a charter, a home rule charter, which is kind of akin to a local constitution. And the primary difference, and we could spend a whole class on municipalities, and people have spent whole classes on municipalities, but the main difference between statutory municipalities and home rule municipalities is that if you're a statutory municipality, you only have the powers. You can only do what the legislature or state allows you to do in terms of lawmaking. Whereas a home rule municipality, you can do everything that the state, you can do anything that the state hasn't explicitly told you that you can't do. So it's two sides of the coin. One is explicit authority, and the other one is you can act unless there's a specific law telling you you can't. So home rule municipalities give a lot more room to roam because these heightened environmental standards, rights of nature laws, as practitioners have argued in the United States in these various cases, really have said that home rule municipalities, because rights of nature laws are not specifically preempted, except in a couple states, which hopefully we'll talk about during this panel discussion, that the portal is open for those home rule municipalities to adopt what they've adopted. And going back to this C-League class earlier, Dan talked to us about the Florida situation in Orange County, the passage of the Orange County law. Orange County in Florida is a home rule county, and so has a lot more room to roam than a statutory municipality. And then, of course, the question, just make a long story longer here, the question ends up as if we're in a state where specific authority is denied to us, in other words, can't find authority as a statutory municipality, or we're a home rule municipality where something's been specifically preempted or put out of reach of the home rule municipality, is there an inherent authority of the municipality to adopt these kinds of rights-based laws? And that really brings us to a point where we're arguing similar to what was argued in the late 1800s, used to be in the United States, that municipalities were recognized as having inherent authority that operated separately from state delegated authority to pass certain things. And I think we're kind of back at that point of arguing that there's an inherent municipal authority separate from statutory authority or from the authority given to home rule municipalities. So it's a jumbled kind of mess there, but as a practitioner, you're looking for, if you're representing a community group, you're looking for a portal to drive this through. And if you're a municipal solicitor, you're trying to close those portals in some ways to make sure that the municipality can't be held liable for passing the law, which is another concern that's been voiced by municipal solicitors. But that's generally the lay of the land in terms of legal authority. So you're either looking for police power authority, general authority that's broad for the statutory municipalities, or for home rule municipalities, you have much more room to roam unless there's been a specific law passed that would preempt or prohibit the adoption of that kind of content in that kind of law.
Great, thank you. And is there more to say about Dillons Rule and why Dillons Rule comes up in this context?
Yeah, so Dillons Rule comes up a lot with lawyers, and there's been about a couple hundred sets of municipal solicitors that have looked at these rights of nature laws over the past 15 years in the United States. So there's been opportunity for development of some of these arguments. Dillons Rule refers to this legal rule that was established in the early 1900s by the U.S. Supreme Court, that municipalities and municipal governments are basically just creatures of the state, that the state can do whatever they want to your municipality. They can abolish it. They can change its lawmaking portals, so put certain stuff off limits to that kind of lawmaking. And Dillon, most people don't explore the rules, just accept it as fact. But John Dillon was a justice on the Iowa Supreme Court. And that's where the phrase Dillons Rule comes from, because Dillon was the guy that wrote it. So he was also an ex-railroad lawyer who had an interest in limiting municipal power. So there was a little bit of bias there as well. But Dillon faced off against Justice Cooley he was the Chief Justice of the Michigan Supreme Court. Judge Cooley put forward, a very influential judge, put forward the concept that people within their municipalities have an inherent right of self-government that can't be defeated by state governmental actions, so that there was inherent authority. You didn't have to look to the state for it, and you just had it, because in Judge Cooley's words, municipalities predated states in the United States. We kind of forget the history of that sometimes, but our cities, towns, villages, and counties predated the formation of states, and with that, basically it came, in Judge Cooley's words, an inherent authority of self-government. And so Cooley and Dillon kind of did battle, not physically, but different states adopted the Cooley Rule, and different states adopted Dillons Rule. and the two went to war. And there was a couple cases up in the U.S. Supreme Court. The U.S. Supreme Court eventually came down on the side of Dillon. So Dillons Rule became ensconced as the federal, the federal rule adopted by the U.S. Supreme Court that municipalities are basically creatures of the state, subordinate to the state in all respects. However, this work around rights of nature and the municipal portal of getting rights of nature laws passed and seeking authority for them has kind of reinvigorated that whole body of law, kind of looking at the various states that had adopted or embraced the Cooley Doctrine and arguing again that there's a right of local community self-government, that it's an inherent right, that folks are not seeking to have the state legislature tell them they can or can't do something, but there's an inherent right of self-governance that's implicit in the very existence of municipal communities. So it's not the law today. It's not seen as the precedential legal doctrine, which is Dillons Rule. But I think, the rights of nature work also incorporates a democratic rights component. And I think some practitioners have been arguing that community rights component ties back into that inherent authority to pass law at the municipal level, which also includes this portal kind of for heightened environmental standards.
Yeah, and at that community level, a question that comes up is, can standing be recognized on behalf of not just individual residents, but on behalf of longstanding environmental groups? Dan, could you talk a little bit about how standing can be used by groups, not just individuals?
Sure. Traditional environmental groups could acquire standing. There are two main ways in which that would be accomplished. The first way would be that the rights of nature law by the municipality would specifically identify environmental groups as having standing in their own right to enforce the rights of nature law. Absent a specific provision like that in the law, traditional environmental groups, if their members are identified in the law as people who can enforce the law, those traditional environmental groups can rely on a doctrine called associational standing, whereby the environmental group, by virtue of having members who would have standing on their own, gets to use their standing to show up as an entity in the litigation to vindicate the rights of nature under the law. So those are the two main ways of accomplishing it. As we saw in my presentation, we don't have a lot of reported jurisprudence on this, but early indications are that courts are resisting the idea of that kind of standing for nature, at least. Environmental group standing is probably easier to accomplish in the near term unless the environmental group is showing up on behalf of nature itself, in which case we run into the hurdles that we covered in my presentation.
Yeah, thank you. And Dan, could you also speak to our next question here? What role does each level of government play at the municipal, state, and federal level? And what roles could they be playing?
Yes, well, at the federal and state levels, in theory, that we could have federal and state constitutional amendments for rights of nature. That's not likely to happen by virtue of the federal or state legislatures themselves doing that. Interestingly, if people live in a state in which they can amend their constitution by initiative, by vote of the people, then there's the option of using that process to try to amend the state constitution. And we learned just recently that, in fact, in Florida, a ballot proposal has been approved for circulation that, if enacted in Florida, would put a rights of nature provision into the Florida Constitution. So again, people in a state that have an initiative constitutional amendment process could use that role. Another thing that federal and state governments could do is to recognize that in environmental regulation, there's a concept of floors and ceilings. Thomas talked a little bit about preemption. Preemption imposes a ceiling. So when a federal or state government enacts a law, it might say that local governments cannot enact more stringent laws or cannot even legislate in the area at all. That's what's called a ceiling. But there's another option called a floor. And under the floor model of things, a federal or state law sets just a minimum level of regulation above which municipalities can go with more stringent regulation. This is not a new concept. Federal pesticide legislation already uses it. So the federal pesticides law expressly says that it imposes minimum standards below which states cannot go, but that states themselves can go above those standards. Now, the federal law doesn't expressly say that municipalities can go above state standards. It leaves that up to the different states to handle. But the concept of a floor instead of a ceiling is something that federal and state governments can become aware of and start using. Municipalities, as we've looked at, the role that they can play is adopting rights of nature laws. Thomas covered in his response to your first question the authority on which municipalities can adopt rights of nature laws. Toward the end, he touched on the concept of an inherent right of local self-government. Even in home rule states, we often find state legislatures passing laws to prevent home rule municipalities from legislating in a particular area. For example, in Florida, after the Orange County Charter Amendment was put on the ballot, and before it was even voted upon by the people of Orange County, the Florida State Legislature enacted a law purporting to ban municipal rights of nature laws. That state ban will obviously be an issue to be resolved in the Wild Cypress Branch case that was filed in April and that we talked about. But municipalities who want to push back against the idea that even in a home rule situation, the state can tell them what they can and cannot do, can look at the issue of the inherent right of local self-government. The theory there is that Dillons Rule and state preemption are actually unconstitutional because municipalities, and in particular the people of municipalities, have an inherent right to govern for their health, safety, and welfare at levels that go beyond what state and federal governments do. In other words, they can go above the floor set by state and federal governments inherently. It's a natural result of the very theory of government in our American Declaration of Independence, which says that governmental authority comes from the people themselves.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Moon. M-O-O-N. Moon.
Thank you. So our next question is, we talked about the legislative bodies and the power to create legislation inherent in the people. What role does the judiciary play? How does the judiciary's role differ in various countries? Mel, could you answer that question for us?
Sure. We start with the premise or the principle that the judicial role is to interpret the law, not to create it or legislate, right? That's the base principle of how and why we separated our branches. But the question is, when they're interpreting the law, our constitutional law especially, and in other countries, their constitutions and their principles, when they are looking at rights, the question is, are they bringing those rights out of thin air? Are they just creating just because out of, on a whim? Or are they reaching into a deeply embedded fundamental concept, inalienable, inherent rights of, basic things like survival and thriving and existing and those types of things? Are they drawing from the premise of the Constitution itself? And in that case, sometimes those types of decisions look like judge-made law, but in fact, they are pulling from the roots of what we are, what our system is founded on. So when we're looking at other countries, for instance, in Ecuador, in that biodigester case, the courts just, without prompting from the plaintiffs, said that, sua sponte, by the way, you guys forgot the the rights of nature, which is in the Constitution, and you need to go back and consider that. In the cases of Colombia and India and Bangladesh, all of those court decisions were also sua sponte, without any pre-existing codification of the rights of nature or legislation. And so they found the premise and the rights, and they declared it. So in that sense, the question is, why not here? We've done the very same in our jurisprudence constitutionally. We said the courts have said and declared that there are fundamental rights to privacy, to family relationships, parenting, and a slew of other things that, from some perspectives, are deemed judge-made law, but in other perspectives, they're implied rights of a fundamental nature that existed, regardless of what we call it. Those are there. And so when we're looking at our own Constitution, we can see from just the 9th and 10th Amendments of our own Bill of Rights, the 10th Amendment bringing about, or talking to the point of whatever the Constitution doesn't include regarding what powers it's delegating to the United States, it goes to the states or to the people. So kind of like a trickle-down effect of power. And in that sense, in that perspective, you discuss the issues of Dillons Rule and creatures of state and preemption powers and what can or can't a municipal government do. But when you're looking at the 9th Amendment, talking about the fact that these Bill of Rights, these enumerated rights are, including but not limited to type of thing. It doesn't deny or disparage the other rights retained by the people. You find and you imagine and you look to the principles of things and find the rights to community rights to local self-government. You find the natural rights of life and liberty as a function of, whereas nature is a function of those rights, and that's where the judiciary's role in this discussion can take place. So that's my answer.
Yeah, thank you. It gets pretty profound.
Yeah.
And Dan, in your portion, you did touch on scrutiny and which kind of triggering words might lead to an interpretation of levels of scrutiny. Is there more that you can see on the horizon in terms of where the judiciary will go when it comes to evaluating scrutiny and interpreting what is being created in specifically in these local municipal laws?
Yes. So because of the way the cases have gone so far, we don't have a direct ruling on whether these rights of nature provisions, how are they going to be interpreted? What are they going to mean? We so far just have courts saying that the municipalities that did them did not have authority to do them. When we get to the point at which we are actually accepting that there is a rights of nature provision that has to be interpreted and applied, As I mentioned during my presentation, many municipalities are writing them to call the rights of nature fundamental and inherent and inalienable. The reason to do that is twofold. First of all, it gets into the authority issue, authority to recognize these in the first place, which Thomas touched upon in his earlier answer. If a right is fundamental, if it is so important to our ordered system of government as to be as to require a government to recognize it, then other levels that becomes part of the authority for recognizing it in the municipal law. The second reason is if a right is fundamental and under constitutional law jurisprudence, then other governments cannot infringe that right without satisfying strict scrutiny. And so if you have a municipality that has a rights of nature law in place, and if you have a state government trying to infringe that right in some way with its own legislation, that state infringement would have to satisfy strict scrutiny in order to defeat the right at issue. And as we remember from constitutional law jurisprudence, strict scrutiny is almost impossible to satisfy. It's set up that way. It's set up to say a right is so important that there's almost no set of circumstances in which a government can lawfully infringe that right. So to answer your question, I imagine if we get over the hurdle of can municipalities enact these in the first place, or if we get to a situation like in Florida, if the voters actually put a rights of nature provision into the Constitution there, then when we're applying it and interpreting it, that's when these sorts of issues will come up.
Thank you. Mel, I have another question for you. You've spent a lot of time looking at what's happening across the country at the municipal level, as well as internationally. What are the most commonly recognized rights of nature today, and what will they be tomorrow from that perspective?
Well, I think that people in general are looking to first and foremost their survival needs. So water is probably the entity that they're most likely to focus on when they're talking about pursuing rights of nature efforts, which is completely understandable. Humans have historically settled in places where there is water and have historically not done a good job at controlling the impacts of our activities to that water. So over time, it's like physics. Over time, it's going to destroy the water and their whole reason of living there. To not just about drinking water supply, but the ability to access the water for whatever reasons, recreational or otherwise. So I think that most of the efforts that I've personally observed, both currently in law and also pursuing in those efforts, have been directed at water, generally speaking.
And we've seen, at least in one instance, a plant species within a tribal community have rights recognized. Are there other potential future areas of development that you see a greater number of plant species having recognized rights, for example? It's really community specific. So whatever might be their priority of effort is likely going to be put on the title line of their ordinance or constitutional amendment effort or initiative. I know that there is at least one community that are working towards establishing rights of pollinators for multiple reasons, not just local benefits, but worldwide, duties and responsibilities of maintaining certain systems in place for our collective survival. And so, yes, it's really currently moved by activists
who have the passion for whatever they have the passion for. And when you're talking about next steps, once this rights of nature doctrine starts to gain traction and start to develop and become a mainstream tool for communities to protect their own natural areas, you'll probably see a greater expansion of rights to larger ecosystems and larger systems.
And just to underscore that point of Mel's on that larger ecosystem question, there was a community in Colorado a number of years ago, Lafayette, Colorado, which passed a right of climate law, basically establishing a right for people to a livable climate. So there was a human right involved in the law that was passed, the ordinance, but also a right of climate. So not a right that accrued to people, but a right of the climate itself to be healthy and flourishing. And it's a fascinating, I think, extension of the rights of nature stuff to climate work, which as a whole, this work, as practitioners will tell you and advocates, is really at the beginning of the beginning, and new applications are coming in daily. But the right of climate and right to climate stuff, there was also a decision in federal court in Oregon in the Giuliani case, the climate trust case that's been going on for a while, in which the judge in that case held that there was a right to climate, a fundamental right to climate, a human right. And that, I think, you're going to see much more of this intertwining between the human right to a healthy climate and also the right of the climate itself to be healthy. So human rights and rights of nature kind of intertwined there.
Mm-hmm. Yeah, thank you. And that's a great segue to our last question. What is the attorney's role in this? And how can attorneys who may be watching this CLE get involved in this growing area of law? Dan, could you get us started?
Sure. Well, there are a variety of options. Many lawyers serve as solicitors of their local municipalities or counties. If you happen to do so, you can study up on the rights of nature and then educate your client, your municipality, about the option for using rights of nature to protect the natural environment in your municipality and to deal with environmental threats posed by polluters and other business interests in your municipality. Along similar lines, a lot of lawyers like to run for local government, and if you have the Constitution for that, you can get into elected office yourself and then use that as an avenue with which to bring municipal legislation to a vote, either by the municipal government itself, or by, if it's an option, putting it out to an initiative vote to the people. A lot of lawyers with an environmental bent are involved with their state or local environmental groups, and often those environmental groups are engaged in the conventional environmental regulatory battles, environmental litigation work. But if you have colleagues doing that work, there's an opportunity to speak with them about the rights of nature and educate them educate them to understand that there's an alternative to the conventional work. Even among environmental lawyers, you'll get different reactions. You'll get some conventional environmental lawyers who are working on the side of the environment, not working on the side of industry, who are derisive of, if not hostile to, the rights of nature concept. I've had conversations myself with such lawyers, but there's also the opportunity to educate and eventually convince people that there are other ways to do things, because lawyers doing that work, can eventually learn over time that it's not working. Thomas won't mind me pointing, to him as a lawyer who began his career working with clients, trying to use conventional environmental regulations to defeat harmful projects. And it was his and others' experience in the usual normal futility of such an approach that led him into the work that he's doing now. So it's not that the lawyers doing that work cannot be reached and educated in rights of nature. So it's worth doing. And then the final idea I have in that realm is if you're in a locality that has an environmental problem, you can get involved with the local group of people who are forming to deal with that problem. They might not yet know about rights of nature. They might be working with lawyers who do not know and who are helping them to prepare the conventional environmental regulatory battle to deal with the problem. If you get involved with a local group of people of that nature, you can educate them to the rights of nature approach to dealing with the problem, and that can lead them to then getting involved with you, along with them getting involved with their local government to lobby the local government to adopt a rights of nature law to solve the problem instead of tinkering with other environmental regulatory solutions. And it can also lead to a process where you find yourself working by initiative to put a rights of nature law on the ballot.
And I would also just to tail on to that I think advocates of rights of nature work really see two very exciting areas emerging. One is law students. So environmental law students who kind of depressed by the existing system or existing state of the planet, and the seeming inability of our environmental legal system to keep up with that. I think students coming in, seeing a new field of environmental law, basically creating positions for themselves or bringing some of these other environmental groups along, the major environmental groups in the United States. And then the second area of opportunity, I think, is the tribes. Tribal governments sit in a much different place than state governments. They have a degree of sovereignty. And so exploring what it looks like for those particular tribal nations to begin bringing enforcement actions in tribal court. So not Western courts with their own, infirmities, some would say, but bringing it in tribal courts and letting tribal courts evolve the jurisprudence on their own to actually give birth to a jurisprudential base around rights of nature. So I think those are two very exciting areas, at least advocacy for rights of nature work. So we are at almost exactly 2.5 hours of the webinar, so we're going to call it a day. Just wanted to thank everyone for taking this class, and a special thank you to the National Academy of Continuing Legal Education for carrying it on this new emerging field of environmental law. If anyone has questions or wants more information about the topics and cases that we covered in the webinar or case citations, you have a slide up thanking you for being in the class. The Center for Democratic and Environmental Rights is the organization that I'm with, and the webpage is there, and also the email, which is info@centerforenvironmentalrights.org. So thank you, everybody, and we're going to close it there.